Uhuru, comrades and brothers and sisters. I want to thank you all for joining us here today. My name is Jaina Bellamumba, and I'm your Southern Regional Representative. I'm the Southern Regional Representative for the incredible and historic African People's Socialist Party. I just want to welcome you to the official live broadcast for the historic precedent-setting Uhuru 3 appeal hearing, where the powerful legal team for Chairman Omali Yeshitela, Penny Hess, and Jesse Neville, they're going to be arguing before the 11th Circuit Court of Appeals in Atlanta, Georgia, to drop the bogus conspiracy conviction charge that remains following the September 2024 trial. You may recall that the U.S. government launched a terrible military assault on Chairman Omali Yeshitela and the African People's Socialist Party on July 29, 2022. And the chairman pulled together the Hands Off Uhuru, Hands Off Africa campaign and won support for the African liberation struggle and the right to anti-colonial free speech from people all over the world and across the political spectrum, which may seem surprising to some, but not once you hear our line. This critical political organizing work secured a victory for the African Revolution and the defeat of the U.S. colonial state's attempt to imprison Chairman Omali Yeshitela and to crush the Uhuru movement. But it was also a victory for all freedom-loving peoples and those who unite with free speech, particularly anti-colonial free speech. This oral argument appeal hearing is another political victory that was won through the leadership of Chairman Omali and the brilliant legal team with Adi Griffin, Leonard Goodman, Mutaki Akbar, Angela Rainey, and Tom Inskeep. Most federal appeals are not granted an oral argument. They're usually decided that, usually only 1/5 get these hearings. And I want to just stop and make sure that I got my facts straight. It says here that the majority are decided on the briefs alone. Recent statistics indicate, let's look here, that only 1/5 of federal appeals in the US are granted oral argument hearings. And the 11th Circuit has one of the lowest rates, granting oral arguments in only 13, is that right? 13.6% of cases, which is absolutely incredible. And it really speaks to the recognition that this case is going to have a lasting impact on the future of the First Amendment forever. In just a few minutes, we're going to be airing the oral arguments live right here from the 11th Circuit Court of Appeals. Following the appeal precedents, we're going to be joined by Chairman Omali Yeshitela himself, as well as the attorneys for brief statements. So if you want to learn about this case, or if you want to read or watch what occurred during the September 2024 trial, visit theburningspear.com and subscribe to the Burning Spear TV YouTube channel. Burning Spear Media is bringing you live the oral arguments to drop the bogus conspiracy charge against the Uhuru 3 and to defend the right of anti-colonial free speech. So we're going to check in, and we'll be checking in shortly. But I just want to reiterate, it says here, I think that it's really precedent setting when we read that only 1/5 of federal appeals in this country were granted oral argument hearings. And I have to repeat it because I think it's just so incredibly profound when we think about, Chairman always says it's not just the right to free speech, but it's also your right to hear what is being said, and particularly anti-colonial free speech is what Chairman Omali Yeshitela is fighting for, the right for all freedom-loving people to have. Again, the 11th Circuit has one of the lowest rates granting oral arguments in only 13.6% of cases. I mean, if this tells you anything, it really tells you that, this case is, I think that they said it's going to set case law, possibly. It's has an impact on the future of the First Amendment. And being able to bring you these live reports directly here in Atlanta from the 11th Circuit Court of Appeals is something that you have to tune into and be a part of. Again, following the appeal proceedings, we're going to be joined by Chairman Omali Yeshitela himself and the attorneys for some brief statements. So we're all very excited to hear about what's going on. I think that this is probably, the most important case. This is the trial was the trial of the century. So we're following in that same trajectory. So visit theburningspear.com. You can also subscribe to the Burning Spear newspaper from theburningspear.com. More importantly, join the party if you align with the politics that you read in the Burning Spear. We have instructions there, and subscribe to the Burning Spear TV YouTube channel. We have an incredible team here that provides you with anti-colonial media, and we are pushing for higher viewership, and we are on the road to 10,000 followers. So we need you to be the next follower and subscribe. So just want to salute everybody for being here. The time is a ticking. So we're going to go ahead and wrap this up. I want to salute everybody with saying a big Uhuru, and I'll see you when we finish on the debrief. Uhuru.
Please be seated. Good morning. We have 4 appeals to hear this morning. Council, we're familiar with your cases. We've read your briefs, the authorities cited in your briefs. We've looked at least portions of the record. You don't have a lot of time this morning, so feel free to get straight to the heart of your argument. You don't need to educate us about the background facts or that sort of thing. We know what the case is about. Pay attention to our traffic lights. When the red light shines, it's time to wrap it up. If you're answering a question from the court, you can finish your answer. Of course, you'll be on our time, but do be mindful of our time. So we're going to begin this morning with United States versus Romaine. Mr. Goodman.
May it please the court, counsel. My name is Leonard Goodman, and I'm representing.
You might lift the microphone. It's not picking you up.
I'm representing Penny Hess, Jesse Neville, and Omali Yeshatela on this appeal.
Okay.
My plan is to address 3 of our claims of error on appeal. I'd like to begin with the First Amendment issue. This is a novel case. It's the first time that Section 951 has been used to directly target speech. The indictment does not allege that any of these defendants conspired to commit espionage or destroy property. Rather, the indictment charges a conspiracy to disseminate pro-Russian political speech, which is described in the indictment as Russian propaganda and disinformation. In DeJong versus Oregon, 1937, the defendant was convicted of organizing a Communist Party meeting. The Supreme Court reversed, and it spoke very clearly. It said, peaceable assembly for lawful discussion cannot be made a crime. The only question to ask is whether the utterances transcend the bounds of freedom of speech, which the Constitution protects.
Yeah, it seems to me the problem here, this indictment seems to be necessarily to implicate speech. But the real question is whether the offense is, that is the failure to register if acting as an agent of a foreign government, is content neutral. It seems to me that it is. It may be that the speech activities would be activities on behalf of that foreign state, that would be evidence that you are an agent who has not registered. But imagine for me, if you would, a hypothetical where the individual was acting on behalf of the state of Israel and was advocating the attack on Iran, which the United States government was involved in as well and was supportive of the United States activities as well. It would seem to me it would be an offense under this statute in that situation just as much as in this situation. So it's content. So it seems to me it's content neutral.
Judge Pryor, certainly the statute 951 is content neutral. It doesn't even mention speech. However, the Supreme Court has made clear in cases like Cohn versus California that if a content neutral statute is used to target speech, strict scrutiny is applied. And here,
but isn't what they're targeting though the failure to register? I guess that's it seems like the act here. No one's saying they can't disseminate pro-Russian propaganda if they want to. They're saying you've got to register to do it.
I think the record is clear that the intent was to target speech. First, if you look at the indictment, as Judge Pryor said, the indictment definitely, in paragraph 2, it talks about Russian propaganda, Russian disinformation.
Sure.
Secondly,
the indictment in Chief Judge Pryor's hypothetical would also say, basically the reason, what you were doing, the unregistered activity you were doing was this speech activity, right?
Correct. I think it's also telling in this case how the government chose to proceed. Because as this court said in Durant, the statute FARA, the statute 22 USC 611 is, quote, primarily aimed at foreign political propagandists and political activists that the United States has an interest in keeping track of. So interesting, in this case, the government didn't use the statute that's a perfect fit for political, if they thought these defendants were political propagandists. Under FARA, there is a willfulness burden for the government under all elements. And generally the way it would proceed under FARA is the defendants would get a letter saying, a letter of inquiry saying, we think you are, from the government, Department of Justice, saying, we think you are foreign agents. You need to register. And the defendant would have a chance to respond to that. That's not the way they proceeded here. They proceeded with SWAT teams at the defendant's homes and offices, took all their files. So I think the record is clear. I don't think the government can credibly argue that this is a content neutral prosecution.
So just to be clear, then you're arguing not that the statute is unconstitutional, but that the prosecution is unconstitutional because it's targeted, the prosecution itself is targeted at, is not content neutral. Is that what you're saying?
Correct. It's an as applied challenge to the statute. The utterances charged here are clearly protected speech. There's no question about that. There's no allegation of incitement under Brandenburg or true threats under Virginia versus Black or facilitation of a crime, words used to facilitate a crime under US v. Wilson. There's no allegation that the defendant's peaceful protests and the publication of their newspaper, The Burning Spear, jeopardized national security in any respect. Moreover, the Supreme Court has made clear that this area of speech, political speech, receives the highest level of protection. Nevertheless, the district court found that speech directed by Russia rises to the level of acts. There's no legal basis for that. And this court should hold that the government cannot criminalize lawful.
Well, just to be clear, though,
speech.
just to be clear,
Yes.
the statute doesn't criminalize being in support of Russia, right? The statute criminalizes failing to register
As a foreign agent.
right? So that's why I'm just, there seems to be a disconnect here. If the statute criminalized being in support of Russia, I mean, you'd have a really easy case. I don't think this would be a problem at all. And if the government's argument to the jury was that these people should be convicted because they're in support of Russia, that's it, then I think you'd have a really easy argument. But I'm just trying to, there just seems to be a disconnect between what they were prosecuted for, which is failing to register, and their speech activity, which was sort of the reason that the government said you failed.
It's kind of hard to understand how you would think the government could prosecute a case where the activity of the foreign agent was speech activity. You would always be able to argue, as you're arguing today, that it's targeting the speech.
That's why I made the point that the FARA statute is the statute intended to go after.
We're not
people.
here to evaluate what statutes the government could have employed to prosecute your clients. The question is whether the statute that is the statute of offense alleged in the indictment and that was presented to the jury and for which the jury convicted your clients is unconstitutional as applied. You seem to be admitting that the statute could be constitutionally applied, but I'm having a difficult time understanding what it is that you think enables us to say that this particular prosecution was unconstitutional as applied, and how we would distinguish that from any case where the foreign agent is engaged in speech activity, whether it was Israel or Russia.
Well, again, Your Honor, it is clear from the indictment that they're concerned with pro-Russian speech.
Well, that's the conduct that they engage in on behalf of the foreign government, according to the indictment. they could have done something else, and the statute would have been violated. Are you saying that you just always get a free pass if the activity for which you're working for a foreign government is speech activity and you just can't be prosecuted for that?
No, Your Honor, but I think you have to be realistic here. The government is not prosecuting people for speaking on behalf of Israel or Ukraine. They are prosecuting people under 951.
I mean, that's usually how you would make this kind of claim, like a selective prosecution kind of claim. I mean, is there any evidence that the Ukrainians, for example, are paying someone to I don't know, propagate Ukrainian propaganda and they're not registered and so they're not being prosecuted? Is there any evidence of that?
Your Honor,
okay. I mean, seriously, that's a real question.
I can't say specifically about Ukraine, but we cite in the brief, there is think tanks in Washington, D.C. that received millions of dollars from Gulf states.
You didn't make, did you, a selective prosecution argument and a record to support a selective prosecution argument? That's a different argument, isn't it?
We did not, Your Honor. We made an argument that this is not a content-neutral prosecution based on the record.
What were you said you wanted to make 3 points. What were the other 2 points that you wanted to make?
I would like to discuss the mens rea issue. And this
What was the third one?
The third one is prosecutorial misconduct.
Okay.
The trial errors. I see my time is up. Do
you have any questions?
No. Thank you.
Let's hear from Mr. Murgo.
Good morning, and may it please the court. Can you hear me okay?
Yes.
My name is Todd Murgo, and I have the pleasure of representing appellant Augustus Romaine in this matter. And I want to use my time to talk about the mens rea argument that this court just mentioned. Obviously, appellant Romaine was convicted and indicted under the same indictment. And, we reiterate Counsel Goodman's argument regarding the First Amendment issue, but the second issue regarding the mens rea requirements. The crux of this argument centers upon.
So your argument is that the government has to prove that they knew about the registration requirement?
Correct.
Okay.
And the crux.
Doesn't precedent foreclose that argument? I mean, in Campa, we held that Section 951 does not require proof that the defendant knew of the requirement to register. 529 F3rd at 999.
And we acknowledge Campa and Duran, and I just want to point out where I think this case is different and where we've come since that time. Okay. And this court in Duran, to our interpretation, somewhat left the door open when it noted that the Duran case did not involve a case where there was otherwise innocent conduct. When I say innocent, both from a legal and a theoretical standpoint, it actually mentioned in a footnote, essentially expressing concerns if there ever were a case arise where there was otherwise innocent conduct and how that would affect the handling or the application of Duran. And substantively, the key difference is that when you're looking at Duran and Campa, those were both cases where when you think of a foreign agent in terms of someone committing espionage or infiltrating United States organizations or the government for nefarious purposes, that's what you have in those cases. On the flip side, I think the evidence in this case and relying on the record, of course, shows that appellant Romaine, as well as the other defendants in this case, took no course of action. And again, avoiding recitating the facts, they were, simply demonstrating and publishing thoughts and opinions that just happened to be critical.
But they were doing that under the direction and control of the Russian organization.
And I'll address.
That's the crime.
Sure, and of course, and I'll address that in the brief time I have. I think that relying on the record, we would disagree with that, being they were, they had these beliefs, longstanding beliefs, and just so happened to collaborate with the Russian co-conspirators, not necessarily under their direction and control. And that's the point we want.
Yeah, but the jury was entitled to hear the evidence and find otherwise, right?
Correct, Your Honor, we were just kind of quarreling with kind of where we've come from, Duran, and that was.
Yeah, I understood your argument about the mens rea to be that Rahafe had abrogated our precedent, and it seemed to me that it hadn't, because Campa made clear that it's a general intent crime. Wasn't that really the argument that you were pressing?
To a degree, we certainly acknowledge Campa, and I just wanted to highlight some of the other cases too that I believe you had just mentioned that seem to contemplate getting to the point where we are today, where you have otherwise innocent conduct, and how there are concerns applying Duran and Campa to a case such as this.
Okay, I think we understand your case, Mr. Murgo. You've saved a minute, and Mr. Goodman saved a few minutes for rebuttal. So let's hear from the government.
Thank you.
Good morning, Your Honors. Joseph Minta on behalf of the United States. The defendants conspired to act as undisclosed agents of Russia, and this court should affirm their conviction. I'd like to start with the First Amendment argument and then move to the mens rea piece. Section 951 does not violate the First Amendment because it satisfies intermediate scrutiny. I'd note at the outset that the defendants don't dispute that if intermediate scrutiny is the standard to be applied, the statute is constitutional. The entire dispute.
You agree that the indictment does implicate speech, right? But your argument, I take it, is that it's content neutral and therefore only has to satisfy intermediate scrutiny.
That's correct, Your Honor. None of the elements of Section 951 implicate the content of the defendant's speech. And that's what makes this case different from the strict scrutiny cases that the defendants are citing, like Cohen. In Cohen, an element of the offense was that the speech be offensive. And so the jury was explicitly required to consider and evaluate the content of Cohen's speech. The jury here could find all of the elements of the offense without ever considering the content of the speech, whether they were arguing that convicted Russian arms trafficker Victor Bout was wrongfully detained or justly imprisoned. If they were doing it at the direction and control of a foreign government, the elements of the offense were satisfied. And that's why intermediate scrutiny is the appropriate test here. It is content neutral, just for the reasons that you were discussing with Mr. Goodman. The second point that I want to make with respect to the First Amendment is that I think looking at some of the time, place, and manner cases from the Supreme Court can provide a good analogy and a good framework for thinking about this. In the same way that you might see a time, place, and manner prosecution for holding a parade without a permit, that indictment might also talk about what the parade was intended to be in honor of. But if it's merely violating a time, place, and manner restriction, intermediate scrutiny is still the standard that this court would apply. If the court has no further questions on the First Amendment, I'll turn to the mens rea piece, where I think your question was exactly correct, that precedent forecloses their argument that there is an additional element to Section 951. This court's decision in Campa and then in Duran was quite clear that that element is not there. Mr. Murgo's argument that the statute ought to be interpreted differently when we're dealing with what he characterizes as innocent conduct does not work from a statutory interpretation standpoint. The elements of the offense can't change depending on the defendant's conduct. And so the only other argument that I recognized in their briefs was exactly the one that the Chief Judge flagged, which was that somehow the Supreme Court's decision in Rahafe and Ruan have undermined Campa and Duran, but they did no such thing. Rahafe and Ruan involved statutes that had explicit mens rea elements, and the Supreme Court applied those mens rea elements to each element in the offense. In contrast, Section 951 does not have a mens rea element, and in Campa, this court explained that when that happens, it's a general intent statute that does not require knowledge of illegality in order to be violated. I do want to briefly note that the constitutional question that the court flagged in Duran that Mr. Murgo was alluding to is not raised in this case. That was a question about due process. And I know some of the themes that have come up in the questions today sort of sound in due process with things like selective prosecution, but that is not the claim that the defendants raised below. It was a jury instruction argument, and it's not the claim that they're raising today. I'm happy to talk about some of their other arguments with respect to jury instructions, But otherwise, if the court has no further questions, we would urge the court to affirm.
Well, could you just address the fact that they were acquitted by the substantive counts, right? And
Yes.
Could you just, I mean, that just seems very odd. I mean, could you just address that oddity?
I struggled with it as well, Your Honor, and the law is clear that inconsistent jury verdicts are not a valid reason for overturning. It's possible that what the jury concluded here was a compromise verdict, or I think you could read the jury verdict to conclude that had the Russians given the sort of direction and control that some of the defendants seem to agree applied to Romain, to them, they would have followed it, that it was an agreement that should that opportunity arise, they would act subject to the Russian direction and control. And for whatever reason, the jury concluded that it hadn't happened. And so they had agreed to, in that future event, commit the substantive offense, but they had not actually done so.
Yeah, because I'll say, I mean, just the one, and this doesn't really fit in a specific box, but like the one thing that seems sort of constitutionally concerning about this is there doesn't seem to be much of a significant line between we want to support what the Russian government is doing for independent reasons, and we're talking to them about that. And, you know, we're acting as their agent and failing to, you know what I'm saying? The fact that they could be convicted of the conspiracy and not the underlying count suggests that, you know, if you want to do something and you're talking to someone else about it, that's enough to convict you.
I think that's precisely a conspiratorial agreement. If you're talking about robbing a bank, you have committed the crime. I do think the point, though, about the fine line is worth discussing briefly, which is that is precisely what the jury was asked to weigh. And the government provided sufficient evidence from which the jury could conclude that this was not done of their own free will, but rather was done at the direction and control of the foreign government. Their closing argument precisely was that this was stuff they were going to do independently and that they were acting independently, and the jury rejected that, and this court should affirm that jury verdict. If the court has no further questions.
I don't hear any, Mr. Menta.
Thank you.
Thank you. Mr. Goodman.
Briefly on the constitutional argument, Cohn versus California, the defendant was prosecuted under a content neutral statute, breach of peace, but the court looked past that and said that this was clearly directed at speech. I'm suggesting that this court should do the same here. With respect to the mens rea issue, the indictment charged the defendants knowingly and willfully conspired to act as agents of Russia without prior notification to the Attorney General. The district court stated on the record, all of these words spoken by the defendants are completely protected. So what makes it illegal is the lack of a reporting requirement. And I have no indication that any defendant was aware of the reporting requirement. This is the issue that was left open in Duran. This court said, well, if it's truly innocent conduct, we don't have it here in Duran, but if it's truly innocent, then maybe it would be a different result. Here, the Supreme Court has been very clear in Rehaf, in Alonis, and in Ruan, that basically they have abolished the concept of a general intent major felony.
No. There were specific mens rea elements in the statutes in Ruan and Rehaf that the court held that the inferior courts had not properly applied. For example, that a felon in possession knew he was a felon when he possessed a firearm. An alien unlawfully in the United States knew that his presence was unlawful when he possessed a firearm. You have to prove the mens rea element as to each of those, but there were express mens rea requirements in the statute. This statute's different, and this is a general intent crime, as we've already held.
In Alonis, Your Honor, the Supreme Court looked at a statute that had no mens rea in it and said, we will read it in because it have to separate wrongful conduct, knowledge of wrongfulness from innocent mistake. And that's what we have here. And the A district judge said very.
I mean, there is a mens rea requirement here. It's just a general intent crime.
I understand that. And that, but the Supreme Court, if you look at Alonis, the Supreme Court said very clearly, we will read it in if there is no mens rea. And here the district judge recognized that Rahoff would appear to be applicable here. The court said, quote, I personally think a very strong argument can be made, very strong, and I'm saying this for the record, that Duran would be looked at differently with respect to this case after Rahoff. If I could make one more.
My time 30 seconds.
Okay.
It better not be a new
Yes.
argument that we haven't heard before.
No, I just want to say what the prosecutor indicated, he was puzzled by the verdict. The own case agents, all three of them, acknowledged that there was no evidence that we were acted under the direction and control.
Okay. I think we understand your argument, Mr. Goodman. Let's hear from Mr. Murga.
Thank you, Your Honor.
Thank you. And I will be very brief. Counsel Goodman, I think, did a good job kind of laying out what we wanted to rebut the argument with. I did want to just highlight, one point that I think needs to be addressed, and I think sums up sort of what we've talked about regarding Duran. And that's in a case such as this, particularly to Appellant Romaine, who was only convicted of the conspiracy charge. And I think the best way to succinctly put this is, how can someone, within the conspiracy framework, knowingly and voluntarily agree to any type of unlawful objective here to violate the statute without actually knowing what constitutes a violation of the statute? And that's kind of in sum the argument I want to present on that issue.
Okay. Thank you, Mr. Murga. I think we understand your case, and we're going to move on to the next one.
Uhuru comrades, we are back live in Atlanta. Shatella and the Uhuru 3 attorneys who just finished. Start again. All right, Uhuru comrades, we're back live in Atlanta, Georgia, and joined by Chairman Omali Shatella and the Uhuru 3 attorneys who just finished arguing the appeal of the bogus conspiracy conviction. We're going to take some brief statements from Chairman Omali Shatella and the attorneys. All media interviews and questions for the Uhuru 3 and their attorneys will be taken at the debrief summation event that's happening at Georgia State University College of Law. That's located at 85 Park Place Northeast in room 139. Uhuru Chairman.
I was thinking that we'd hear from the lawyers first, if that's all right. Do you mind? Yeah, I think that, yeah.
Okay, Uhuru. Attorney Leonard.
It's an important case. These defendants were targeted for political speech. That's almost never happened. The Supreme Court has condemned these kind of prosecutions for almost 100 years. So I think we gave them a lot to think about in this appeal. We'll see where they end up, and we're hopeful.
Uhuru, thank you. And from Attorney Angela Rainey, Uhuru.
Uhuru, Leonard did a great job presenting argument, and I think I echo his sentiments that this is a free speech case. This prosecution was in violation of the right to speak freely, and we'll wait to see what the court has to say. Thank you.
Uhuru, Chairman Omali Shatella.
Uhuru, thank you so much. I'm really appreciative of what has happened up to now. What happened in the court just now. We have extraordinary lawyers who presented extraordinary arguments to overturn this conviction, extraordinary conviction, I should say. I felt the arguments went well. Some people were concerned because the judges seemed to be fixated on the issue of having not registered as a foreign agent. This is one of the things they convicted us of. It was an extraordinary conviction because we were found not guilty by a jury of actually working for Russia as Russian agents without notifying the Justice Department. And now we have a situation where we were found guilty of not registering to conspire to work for the Russia as a Russian agent. It's an extraordinary kind of conviction. The judge was saying this throughout the process. I am not pessimistic about how the discussions went today. And one of the things that impacts on the limitations of my of pessimism is one that these cases are not heard regularly, ordinarily. The court doesn't take these arguments. And secondly, they seldom give people an opportunity for oral arguments. So that was a good thing because we feel like the court itself recognized there's some issues that need resolution. And despite what we heard coming from the judges that might have made some people pessimistic, the court clearly felt like that these were issues that need resolution and that they are unresolved. So that was one thing that I felt good about. And another thing I felt good about, in addition to the extraordinary job that was done by Comrade Attorney Leonard Goodman, is the fact that the prosecution did not have a reasonable explanation for why we should be facing charges on the second offense, that is to say conspiracy, when the jury had found us not guilty of the foundational charge, and there was no meaningful response from the prosecution around that. So I felt like that was also part of what made me feel pretty good about what has transpired up to now. And then I should say this: the federal feds, the Justice Department, the FBI. They like to boast about the fact that they have something like a 97% conviction rate. And one of the reasons they have a 97% conviction rate is when people roll up to your houses with armored vehicles and flashbang grenades and using laser targeting devices for you. Most people have simply surrendered. They have taken deals that the prosecution will offer you. People are intimidated so much that they often don't utilize what's supposed to be a constitutional right to appear before a jury of your peers, etc. This instance, of course, it didn't go that way because we fought. And the reason we're standing here today is not because it's because of the fact that we resisted. The reason the court had to hear us today is because we resisted. And so the thing that I think fundamentally important here is that people need to understand that you have to fight injustices and you cannot be intimidated and fearful of what might happen if you fight injustices. And the one of the initial, the first motion that was made to dismiss the indictment, I thought was really important by Attorney Leonard Goodman, is he said even the indictment itself is an attack on free speech. It's an attack on free speech. And nobody in this country has a connection to the struggle for free speech more than Black people. That's right. Because when you look at the issue of the First Amendment, the Bill of Rights of this, I think it was 1797, when this was adopted by the US Congress. At 1797, African people were property. So we had no rights. There was no assumption that it was for us. And this is what I'm hoping that particularly white people will come to understand, that they didn't, when they came with us around free speech issues that we never had, then it's not us ultimately that they're coming for. They're coming for you. Yep. Because there's a presumption that you have free speech rights. And so when they attack free speech, First Amendment, et cetera, it's an attack on everybody. So I just think it's important. It's very good for us. Thank you so much. We've got extraordinary lawyers and here, yeah, extraordinary. These some bad lawyers. Yeah. And so I'm so appreciative of all of you and everything that's transpired. We'll be talking a lot more when we're summing up, debriefing as it's characterized, Uhuru. And I talked too long.
Would we like any more words?
Just briefly, we're here today to change the law, ultimately. We're here today to create new case precedent for generations to come, and that's an extremely hard thing to do. I can't tell you how appreciative and proud I was of Attorney Leonard Goodman for standing his ground in this quest for resistance against this injustice. He really presented our legal arguments well. He battled till the end, and I'm hopeful and confident that we will get the result that we are looking for. Well, thank you.
Uhuru, and that just to know that is Attorney Addie Griffin. All right. Would you like to say any words? All right. Uhuru, comrades. I just want to thank everybody for coming out, comrades, to stand in support of the Uhuru 3 and the right to anti-colonial free speech. And Burning Spear TV is going to be live again momentarily for the debrief and the summation that's going to be happening at Georgia State University College of Law. Meet us at 85 Park Place Northeast in room 139 and join us back here within the hour. Uhuru, comrades. Right on. Uhuru. Right on.